I'm searching for that silver lining. Horizon that I never see. Good morning, all. Had a little technical issue there. I was having trouble getting on, so I'm glad you are here. Because it was my error. I'll take the hit. We'll call it operator error. I'll give folks just a minute or two to jump on. There's a good number of you this morning. Wow. Hey, cool group. Good morning, Kyle, Millie, bienvenidos. You can tell me how I did later. Adam, good morning. Pamela, good morning. Shane, good morning. Tim, great to see you on here. And Todd. I am not technologically like awesome. I will admit that. So sometimes it takes me a minute, but we're here. Those of you that are new to my webinars, that is the legendary and fabulous Commodores featuring Lionel Richie on lead vocals. I have been using that as the theme song to my Zoom series since the beginning of the pandemic. As a child, our family lived in Tuskegee, Alabama, which is the home of the Commodores. And in fact, the town square has been renamed Commodore Square. Little interesting tidbit. I see people are still dropping in, so I'm going to go one more minute and we'll get started. I do want to be sure, I believe this was mislabeled with next month's topic. This morning, I'm going to be talking about trusts, revocable and irrevocable. And next month, I'll talk about keeping private property ownership private. So these have been over the years two of our most popular subjects, which is why we are touching base back on them this autumn. By the way, happy fall. So if you were only here about real property titles, I'm sorry to disappoint you, but I promise in 1 month we'll touch on that subject again. If you have an urgency, you could go to our website, which is rocksolidlaw.com, and then you'd go to the videos page. I believe you have to enter your email address or something so we know you're a real human being, and then that gives you access to our entire video library, which inclusive of some other ones on real property. All right, thank you, Lionel Richie. You are fabulous as always. My favorite Commodore song, of course, is Brick House, which was sung by the drummer. Little tidbit for you there. All right, hello, hello, hello. I am John Miller. I founded Rock Solid Law and Title and its predecessor firm way back in 1991. And from that time to this, have enjoyed practicing in the areas of estate planning, which we're going to talk about this morning, last wills and testaments, all sorts of different trust documents, many different levels of planning. Have been delighted to be invited into a national collaborative in that regard, featuring some of the finest high wealth planning attorneys in the country. And I, with all humility, consider myself to be a very good estate planning attorney. I have the great privilege of co-counseling with great attorneys. So we really can help anybody, really, other than the lowest 5 to 10% of the socioeconomic group in America, in Florida. My collaborative is countrywide and even international. If there are people that are not really eligible for our practice, I have great referrals to that too. So while I'm thinking of it, having practiced almost 40 years, I feel like I really know a lot of the most honorable and best attorneys and other professionals in Northeast Florida. So if you need a referral, we are just delighted to get you to the right or a good person, or if we don't know who, to a person who we feel very confident will tell you who. The rest of the practice, of course, we close real estate, residential, and commercial professionally and on time. We're a boutique title shop. I have a wonderful team that works on the real estate side. We never want to grow to be huge. We want to give individual service to every file. And that is sort of my personal motto. Our baseline is excellence. If we're not going to be excellent, we're not going to provide the service. And then finally, being an entrepreneur myself, I love entrepreneurs, and part of our practice that I truly enjoy, along with Walt Unfricht, our other attorney, is helping entrepreneurial small business owners grow their firms, make great decisions, enter good contracts, and check the downside of any transaction that they may be in, so that we can help a bad deal not kill a company. Love entrepreneurs. So people ask me, "What's your perfect client?" Oh gosh, it's a small business owner who has a family and is growing their business. We can really benefit those people well, because we help them with the business side, we help them with their family planning side, and then with those sorts of folks, there is always residential and commercial real estate in the mix, and we just love being teammates with those kind of people. So trust is a huge word. There are probably hundreds of kinds of trusts. Most of them we don't come across daily. All of them we consider for every client to determine what is the best to resolve the opportunity or issue that person or family is facing. And so today, people ask me, what is a trust? Well, it's a lot of things. But one thing that it is not always the same. Okay. So there's really more or less, well, there are multiple kinds of revocable trusts, and there are many, many, many kinds of irrevocable trusts. So I'm going to start with the simpler of the two, and that's the revocable trust. You may hear it called a living trust, a family trust, an inter vivos trust, if you want to whip your Latin out. All the same thing. What it means is it's a trust established during the lifetime of the settlor or grantor, the person making up the trust, right? And that person reserves the right to him or her or their selves to make changes as they see fit during their lifetimes, meaning that they can go back and add in a child who may have been disfavored at the time that they were setting it up. They can also cut somebody out. They can add a new charity. I've had clients delete charities that they didn't like the direction they went in. They can make parameters for behavior of the beneficiaries. If the trustees believes that there is a likelihood that the beneficiary may be hooked on legal or illegal drugs, testing can be required in the terms of the trust. What I tell my clients is essentially anything you can come up with, we can write into the trust as long as it's legal, right? I can't write illegal terms. Fortunately, I have amazing clients, and I've never been asked to write an illegal term, but I always lay that out at the front end because I won't do it. If you want somebody that's going to play, all of us write in the gray area, of course, but if you want anybody to cross a solid black line, I'm not the lawyer for you, right? So what is great about a living trust, a revocable trust, an inter vivos trust? To me, the two outstanding features of it are, one, it avoids the probate process. Here is a point to get to today and hang on to forever, all right? Every last will and testament that is not done as a pour over will in conjunction with a trust is going to court. It's going to probate court. In fact, there's a law in Florida that within 30 days of the death of the decedent, the original of their will is to be deposited in the registry of the court, filed with the clerk. Doesn't always happen. There's no great penalty for not doing it, but it's the law that it must be done so. So people, after somebody dies, call and ask us, what do we do? That's the first thing I'm going to tell them. But if they have a trust, all you do is file a notice of trust and you are done with the court. What's good about that? All right, well, first and foremost, I'm not going to get on a soapbox, but it's pretty clear to me that a lot of people in this country didn't pay attention to civics over the last 50 years. We have three branches of government: the executive, the legislative, and the, come on class, judiciary. Oh, the judiciary is a branch of the government. Yeah. Who's the will go in front of? The government. How did that judge get to be a judge? He was either appointed by a politician or elected, and therefore is a politician. So if you want to leave somebody in charge of your estate and handing out what you have left to those you love most, and you leave a last will and testament, you're basically asking the government to be in charge. What's wrong with that? Well, for those of you that don't already have an opinion that there's something wrong with that, it is, in Florida, expensive. Your heirs are going to spend $3,000 anyway, and more likely 5, 6, 7, or 30,000 to get through the probate process, depending on the complexity. Do some get through for a couple $1,000s? They do. They do. Typically, those are families that I call it a palm tree family. One, all the way down, no branches on the family tree, or a very small estate, right? If you have less than, I believe it's 75,000 now, there is a summary procedure you can follow. We don't really deal with a lot of those in our practice, so I don't see that a lot. We also, by the way, we will handle a probate for a family that we didn't get to plan away from it if they are not fighting. I'm just over being hired to fight over other people's problems. That's just a business choice for my firm. The people sitting in my lobby are typically very happy people. They're buying or selling a home. They're about to take care of their family. They are doing something exciting for their business. I don't want fighting, squabbling families sitting in my lobby with those other people, bringing them down. So that's just our choice. I can tell you where to go. Oh, I didn't mean it that way. I can give a great referral to excellent attorneys who will handle a problematic probate, but we're not going to do it. Why? Because I believe we have the best court system in the world on balance. What does that mean? Some of them come out over here, some of them come out over here. In the middle, it all works out to like the best, right? But back when I litigated, I promise you, I won cases that I didn't believe I had the equities. And I lost cases that I really believed that my client was right. So I don't like to send my clients to court. First off, it's expensive. Second off, it's public. People can see what happened. People can, your dirty laundry is aired for all the world to get in and look at. Third, it takes time. People say, oh, it could be over in 4 or 5 or 6 months. Yes, it can. It almost never does. It almost never does. Try to get a hearing in front of a judge. Even with Zoom hearings, it takes a long, long time for probate to happen. And during that time, your money's tied up, and those that you love the most usually can't get to it until the judge says they can. So the judge says they can is the next point about probate, because your poor personal representative is going to have to what's called marshal the assets. That means get everything together in an inventory and present it to the court for their approval. Why do they do that? They want to make sure all your creditors are paid. They want to make sure that at credit card or somebody comes out of the woodwork and says, I did some work for them, they owe me money, files a claim. Wow, what has to happen? You've got to file an objection to that claim. More court work, okay? So it drags on and on and on. It's public and it's expensive. And in my nearly 40 years, my opinion is it's where families go to fight. Whenever I give a public talk about estate planning, heck, it might be about real estate. Somebody comes up to me after and says, let me tell you what Uncle Bill did at the funeral. It happens all the time. A widow. Wow, my stepkids asked me how soon I'd be moving out of my house. You don't want that. So really, what do we do in this firm? We help people with their legacy, right? Because it's your legacy that's tarnished. It's the decedent's legacy that's all messed up because they didn't bother to leave a trust with instructions on what to do. So that's the first great thing that a revocable trust can eliminate from the future of your family. Keep you out of court, keep you out of probate. The next is it's the only way that you can control the distribution of your assets beyond the date of your death, right? With a will, it says, give this to Sally, this to Sue, and that to Hermie, and we're done. What if Hermie's like not so good with money? What if Hermie's got a really difficult spouse that you can see the divorce coming? What if Hermie's just not good with money and needs not to inherit it all at once? Guys, there's nothing as bad as an 18 or 21-year-old inheriting $1 million. It's gone in no time. What's wrong with that? What's wrong with that is they live a life of regret knowing they blew it, right? And everything you left to prop up their lives vanishes, I'm going to say in a puff of smoke, or whatever their recreation of choice is. Vegas trips, gambling, I don't know, just living beyond their means, and that money can be gone very, very quickly. But with a trust, you can say, wow, I think people make better decisions at 30, 35, 40, even 45 than they do when they're 21. So you know what? When they're 21, if I'm not around to pay for the college, we're going to do that. We're going to help them when they need it. We're going to tell the trustee, give the trustee some discretion to help them when they need it. But until they make good decisions on their own, we're not giving them that money. And that's what a trust can do that a will simply can't. A will can set up what's called a testamentary trust, or a trust that comes into being after you're dead. But guess what? You got to go to court to do it. So there you are back in front of a politician or a judge who's in charge and making every year the person in charge do an accounting to the court. Under the trust, the only person they have to account to is to the beneficiaries, right? As long as they're doing what they're supposed to be doing, upholding their fiduciary responsibility, there's no problem at all. So that's, to me, is one of the greatest things as well that a trust can do. It really does protect your legacy and builds a strong family. And that's what I'm all about, is building strong multi-generational families. So if that's important to you, you need a trust. Okay. All right. So why would you want a revocable trust? So you can change your mind later, right? So you can alter what you have chosen to do merely by amending it. Now, often we deal with married couples, sometimes unmarried couples, right? So typically the couple wants to decide together what's going to happen to the wealth they've built. And during the lifetime of both of them, the trust remains revocable. At the death of the first, the trust often becomes irrevocable. Pause for a moment. Revocable, irrevocable. I am pronouncing that way just so you clearly hear the difference in what I'm saying. The pronunciation for each is correct both ways. All right. So revocable, revocable, irrevocable, irrevocable. I've chosen to say revocable and irrevocable just so you clearly hear which one I'm talking about and don't have to get caught up in trying to figure that out. So at death of the first, with some couples, they're cool with the second one making changes during their lifetime as well. But what it's protecting against is an interloper coming in, maybe taking advantage of them in elder abuse. Maybe the next relationship is more about the money than love. And then that person has a really good idea of where everything that couple worked for should end up going, like to their heirs, right? Rather than to the children of the original couple. So there's a choice on making it irrevocable. But during lifetime, why would you make something irrevocable? Well, there are lots of considerations for an irrevocable trust. Primarily, we're going to be going in asset protection, tax planning, and multi-generational planning. And I'm so proud when I said those words, everybody didn't drop offline. So, irrevocable trust, many kinds are available to us, and it just depends on the individual situation on what we might use. I want to make this point. Typically, you can't change an irrevocable trust after it's created. However, there are ways of doing that. I caution you that they are difficult and expensive and can involve court to decant a trust and change it. So really, you want to keep the things you think you might want to change on the revocable side. And then maybe you're thinking, I'd like to get some assets out of my estate, right? And let them grow away from me, maybe for my grandchildren, or maybe just to keep them away from a creditor, because I know that some of the business deals I do could have a downside, and I sure as heck don't want to have people to come back and be able to get all of my assets. Now, first off, in Florida, you can find the homestead video on our website. In Florida, your homestead is nearly inviolate except to the tax man and to your mortgage company. Oh, and a guy who swings a hammer. You got to pay them, or they can get a lien on your house as well. Another point, my associate was just on the news last night. Your homeowners association could get a lien against it. So I always advise people, when you get mad at your homeowners association, go argue at the meeting, but don't withhold payment. So once you set up an irrevocable trust, it gets its own EIN and must file a separate tax return. But this gives you greater protection from creditors and estate taxes. Now, in Florida, we don't have a Florida estate tax at this point in time, but as long as we can keep tourists coming here and paying all the bad taxes, and as long as real estate stays good enough that there's lots of money collected on notes, mortgages, and deeds, I think that we will have neither an estate tax nor an income tax in Florida. Just an opinion, but I've lived here well over 40 years, over 45, I don't know, most of my life. You can set it up during your lifetime, and there are a variety, as I said earlier, of types to choose from. And it just depends on your circumstances. So we have to talk, or you have to talk to somebody who has expertise in this. I've got to find out what it is that you're trying to accomplish. Often, there's gift tax to consider as well. And often you'll set up something like taking a life insurance policy, one that's going to gain value, and wrapping it in an ILIT, which is an insurance trust, an irrevocable life insurance trust. And then you can gift to that ILIT, because it's a separate individual from you, annually. And you use those gifts to pay the premiums so that the life insurance policy grows, ready, drum roll, tax-free in that policy. Pretty cool, huh? In that trust. Pretty cool, huh? The policy inside the trust. So, things we're going to talk about in an irrevocable trust. Oh, by the way, I know I started a little late, but I will sure try to take any questions that you might want to throw at me. And there's a question and answer and a chat button at the bottom along there. If you want to throw it in, I'll do that at the end. If it is something that's very personally, factually related, I'll just go ahead and let you know now. For attending today, I'm going to offer to have a sit down or a consultation, if you want to call it that, with you to answer your questions at no charge. So if it's that kind of thing, let's talk about it individually, because most folks don't really want everybody that's on this call to know their personal facts. But if it's a broad general question, I want to hit it, because I really want these webinars to be about what you care about. All right. And I know I started a little late and I'm going a little long, but I'm going to finish this subject with you. And if you have to drop off, you can certainly go watch the video. It should be up pretty darn soon. I see a couple people dropping off and joining as we're going. So why would you set up an irrevocable trust? Here's the things you might think about. To transfer wealth to the next generation, to keep a family business in the family, to leave a legacy with a charity you support, and there's tax benefits to that, to minimize estate taxes for you or your beneficiaries. And let me just say this. I am all in favor of our clients paying mandatory taxes, right? I drive on the road too. The sewer takes my water away. There's services our government needs money to run, and we should all pay the required taxes. However, I'm not in favor of my clients paying any voluntary taxes. If we can use legitimate methodologies to remove your requirement to pay taxes, we're going to do so. There'll be an expense, and you have to weigh the expense versus the benefit, right? That's the way life works. Butterfly flaps a wing in the Amazon, right? Oh, John, you're on a tangent again. Also, irrevocable trust shield your assets from creditors. That's a great one. That's a lot of fun. So they're just all kinds of different ones, and you probably heard of ILETs, GRATs, CUPERTs, charitable remainder annuity trusts or CRUTs. There's just special needs trusts and generation skipping trusts, right? There are all sorts of things that that need attention to correct in your current situation to make your own future life and the future of those that you love better. I see a hand up. Shane, I don't know how to do that. If you'll just type it either in the chat or the Q&A, I'll be glad to respond to it. So, as the name implies, irrevocable trusts, irrevocable, cannot be changed, and therefore all these other benefits can be obtained from them. Although we know that there are legal means to affect changes in many instances. Okay, so there may be a tax consequence of making that change. There may be a loss of asset protection consequence to making that change, but it may be outweighed by whatever the situation is that would allow that change to be made. So in each case, you will have a trustee and beneficiaries. In the revocable situation, you can be your own trustee and maintain complete control of all of your assets. In the irrevocable situation, you need to have somebody else as trustee. Typically, that is a trusted and honored family member or close friend. There are also private individuals as well as trust companies that will provide those services as well. So in each case, we just have to consider who it is that that we would want to appoint as trustee. Okay, did I get the question? I don't see Shane. There you go. Let me get my glasses on. Anybody else that's got one, put it in now. And then I'll wrap up after this. As I said, if you have a question that is individual or more sensitive than you want to put up online, just write it to us at questions, that's plural, questions with an S on it, at rocksolidlaw.com. Also use that same email address to make a consultation, and just let us know that you attended this webinar, and we will waive the fee, which is, I believe, about a $500 savings to you, and just my gift to you for spending your valuable time with me this morning. All right, I'm going to hit this question now. Okay. Okay, so the question, you guys can go look at it if you want, is pretty fact specific. But Shane, It depends on when the trust was created. There is a 5-year look back. So with any luck, that trust, that irrevocable trust was created more than 5 years ago, and the properties were transferred into the trust more than 5 years ago. So if that's not the case, I'd love to have a consultation offline. I will tell you that Medicare, Medicaid is not my specialty, but I can bring in somebody to work with us on that. That's a great question. So the question is, whether essentially an irrevocable trust can offer protection for somebody who's going into a group home, independent or otherwise, living facility. And the concern is whether Medicare will be able to come back after the assets of the irrevocable trust, where that asset in this case happens to be real property. So I would love Shane to consult with that client, or if not me, get somebody else to help with that. That's qualified, because that's very fact specific, and obviously the real property is probably valuable, and there's a big downside to not getting it done right. Says it was less than a year ago. That's problematic. So depending on how quickly the dad's going into that facility, quick action might be appropriate. Obviously, I'd love to help with that. So 904-241-1113. And let's see if we can't help that client out. They've got a lot at issue. Kyle, nothing would please me more. So I will look forward to that. Anybody else? I see people are starting to drop off. So I guess I've talked long enough. I really enjoy doing this. Anything I know, I want to pass on to you guys, at least so you can identify the issues, for the folks that you work with. And I would be absolutely delighted to see any of you come in to consult. Oh, man, you're so welcome. And I hope I'll be seeing you soon. Guys, anything else, give us a buzz at the phone number 241-1113. Of course, that's area code 904. We are located in beautiful Ponte Vedra Beach, Florida. Just love living at the beaches, man. I got out on the beach this morning. It was high tide. There's a 17-mile-an-hour nor'easter blowing, and it was absolutely gorgeous in the dark to get my exercise. Anyway, I will hopefully hear from some of you guys, and we will be next week talking about privatizing your real property and keeping it secret. So listen, here's the Commodores. You guys have an awesome day. And once again, I'm John Miller, founding and senior attorney at Rock Solid Law and Title. Dance party? Welcome, Angela. Cool, Kyle. See you on that one. See you soon. Maybe this afternoon. We're the last ones on. Cheers. Over and out. Wait a minute. I love that part.